Welcome, and thank you for viewing this Garden State CLE video. All Garden State CLE video programs can be seen for free 24 hours a day. Besides viewing the show, you can also earn CLE credits. In order to receive CLE credits for this program, you will have to do the following. First, download an evaluation form from the website. Just click on step number 3, and the form will appear on your screen. Please print out a copy. Next, as you watch the program, you will note that from time to time, a keyword will appear on the screen in red lettering. Write these words down on your evaluation form. Accurately recording these words is a required step in granting you CLE credits. Finally, at the conclusion of the show, simply complete the evaluation form and fax or mail it to Garden State CLE. Remember, viewing the CLE program is absolutely free. The only time you ever pay is when you want to receive CLE credits. You can pay for your CLE credits online or by sending in a check with your evaluation form. Now, sit back, relax, and enjoy the following Garden State CLE video from the comfort of your own home or office.
Garden State CLE. 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 Garden State CLE.
Bob, so in preparation for our talk today, I was reading over a whole bunch of cases, and it came to mind that we take for granted in this day and age that counsel being appointed to indigent people in municipal courts, and then the counsel getting paid for that work, we really take that for granted, because it seems that, and I really was not familiar with the history of this issue, that back 50 years ago, that wasn't actually the case. And it became really telling to me where we've come over that period of time.
Just to give some thought to the thousands of people who are touched by a system now that provides appointed counsel for indigent people who are charged with offenses that are not considered to be crimes, petty type offenses. There are, I would say conservatively, thousands of people who get the benefit of this proceeding where counsel is appointed for them. And I dare say that neither the attorneys nor the defendants, and many times the judges, realize why they're doing it and what went into this and the struggle that was behind it. It's quite an amazing story when you stop to think about it.
It is, definitely, and it's interesting even to see the courts talking about the issues of whether it's a constitutional appointment, or is it just in the interest of fairness that a judge would appoint an attorney to represent an indigent individual. So it's very interesting how it's developed, and we definitely don't appreciate where we've come or how far we've come over the years.
Yeah, it's actually, it won't be long before we'll be really literally 100 years into this struggle, which now seems to be pretty well decided in procedural sense and in a constitutional sense. But there was a time years ago when people charged with state crimes, even serious crimes, even capital offenses, didn't necessarily have the right to an attorney to help them.
But they do, and how did that come about? Well,
I think the starting point on all this, you have to go back to the United States Constitution, to the Sixth Amendment, which provides for the appointment of counsel for people who are charged with criminal offenses. But of course, having that in the Constitution and having it be a reality are two different things, because it's one thing to constitutionally mandate that counsel be appointed, but it's certainly another to have them paid and have the legislature come up with the necessary money to pay for the expenses and the costs of having these individuals represented. And just to make matters even more complicated, you're talking about the legislature appropriating money for criminals and for the benefit of criminals, and that doesn't, from a political standpoint, that doesn't have a lot of traction. Nobody wants to be the politician who was concerned about giving prisoners extra protection in the courtroom. Okay, but that's just the way it is. The Constitution says what it says. I guess you really have to look at the watershed moment in all of this as the so-called Scottsboro boys case, Powell versus Alabama from the 1930s, where the United States Supreme Court really held for the first time that in circumstances where you're dealing with capital litigation, and the people are just really not readily able to represent themselves adequately, either because of ignorance or lack of education or the complexity of the case. Many times it would be because the people can't read, or they may have some type of feeble-mindedness. But whatever the reason was, if a judge made a determination that the defendant was not able to readily represent himself, then counsel was to be appointed. This was really something that was done not on the basis of the 14th Amendment in the due process concept, but rather just that to do otherwise is really kind of shock the judicial conscience. It seems that every time the Supreme Court wanted to make some part of the Constitution apply to the states and wasn't able to utilize the 14th Amendment or wasn't ready to utilize the 14th Amendment, they would justify it on the basis that the conscience of the court was shocked. All right?
Right.
So the Scottsboro boy case, Powell versus Alabama, was kind of the opening salvo in that. The next exploration of this came, and I think the year was 1942, in Betts versus Brady.
Right.
And Betts versus Brady really was, at the end of the day, the first salvo in an attempt to see whether or not the 14th Amendment would apply to the states in the sense of people being charged with criminal offenses in the states being entitled to counsel. And the Supreme Court was just not ready to do that at that point. Remember, this was during wartime, number one. Number two, dealing with a very, very conservative court. And I think just in the interest of federalism, the court was very, very reluctant to order some radical new procedure on the states that would cost them money because of their respect for the individualities of the states. This was really, an issue of states' rights, so to speak. And the states were supposed to be able to be their own little laboratories and conduct their own state criminal prosecutions as they wanted. It really wasn't until another 20 years later in Gideon versus Wainwright that the law changed markedly. And again, there was still some concern among the justices about the extent to which the 14th Amendment would apply to states. In other words, if the Supreme Court were to order that defendants have a right, when they're charged with criminal offenses, to have attorneys to represent them if they're indigent, what are the outside parameters of that? In other words, how serious does the crime have to be? Could it be something that's less serious than murder but more serious than a parking ticket? How are the states going to pay for all this? It was kind of a giant leap. But the thing with the Supreme Court was, by the time that Gideon versus Wainwright came around, many of the states on their own, and I'm sure it was more than 30, had independently taken the step where under their own state laws or state constitutions they had found a right for indigent people to be represented by attorneys in criminal cases. So when the Supreme Court decided Gideon versus Wainwright, it knew that this was something that there was a very small minority of states at that point that this would really impact on, because the vast majority of the states it wouldn't have meant anything to them because they'd already done it on their own. We have a little clip of Gideon versus Wainwright that I'd like to show, and of course then, as of now, there were no cameras in the Supreme Court, but my understanding is that the people who appear in this were they utilized the actual transcript of what was said in the courtroom. So I want to kind of take a look with you so we can discuss it. One thing I want you to take a look at, apart from the hesitancy of the court to kind of get involved in this because of the impact it would have on these issues of federalism, there's really no clear delineation as to where the cutoff would be, in the sense that, are we talking about just criminal offenses, or do we want to include petty offenses as well, traffic tickets and things of that nature. So.
And that seemed to have been the concern in the Betts case, that they didn't want it to get down to traffic court, and where would it go if they were to decide that the appointment of counsel was necessary?
Right, and as you'll see from the argument, the Supreme Court was very, very concerned about the precedent they had set in Betts, but 20 years had gone by, and there had been a substantial movement among the individual states to provide counsel, so it was really not as controversial as it seemed initially. But let's just take a look at the video.
Sounds good.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Number 155, Clarence Earl Gideon, petitioner, versus H.G. Cochran, Jr., Director, Division of Corrections, State of Florida.
Counsel are present.
Mr. Bordis.
Mr. Chief Justice, may it please the Court. This case presents a narrow question unencumbered by extraneous issues. Clarence Earl Gideon is supposed to have broken into the Bay Harbor pool room and stolen some wine, some cigarettes, and an unstated amount of money. He was arrested and put on trial. He asked the judge to appoint an attorney to defend him, and the judge refused. Thereupon, Gideon did the best he could to defend himself. He was convicted, sent to the penitentiary for 5 years. The record does not indicate that Gideon was a person of low intelligence, nor that the judge was unfair to him. But to me, this case shows the basic difficulty of Betts versus Brady. It shows that no man, however intelligent, can adequately conduct his own defense.
That's not the point, is it, Mr. Fortis? In the Betts case, this court did not go on the assumption that a man can do as well without an attorney as he can with one, did it? Everyone knows that isn't so.
I entirely agree, Mr. Justice, with the point you are making, namely that a man cannot have a fair trial without a lawyer. But the Betts case held that this consideration was outweighed by the demands of federalism. In other words, the Betts case expressed the feeling that this court had at the time, that the state of Florida, or any state, should have the right to decide for itself whether defendants in their courts should be entitled to counsel. The Supreme Court of the United States should not impose that requirement upon them. But, Mr. Justice, this court has held many times that when there are special circumstances, a defendant is entitled to counsel in the state courts. I have now read all the cases on right to counsel questions, beginning with the famous case of the Scottsboro Boys in 1932, and it is a fascinating inquiry. As I read the opinions of this court, I hope I may be forgiven for saying that my heart was full of compassion for the judges having to review those records, look for special circumstances which might entitle a defendant to counsel. Such case-by-case supervision of the state courts by the Supreme Court cannot be wholesome. Intervention should be in the least abrasive, least corrosive way possible. Of course, this special circumstance approach is wrong. How can a trial judge, when a man is arraigned, look at him and say there are special circumstances? Does the judge say, you look stupid, or your case involves complicated facts? It is administratively unworkable.
The states are recognizing that.
Some of them are, Mr. Justice. Professor Camisard's research indicates that 37 states now provide counsel for poor people in all felony trials. 8 others frequently do so as a matter of practice, and 5 make no regular provision for counsel except in capital cases. But I do not agree with any implication in your question that this movement by the states to act themselves argues against a step forward now by the Supreme Court. I do believe that the growing acceptance of right to counsel by the states makes a reinterpretation of the Constitution easier. I see my time is almost up, so I will try to sum up. I believe this case dramatically illustrates that you cannot have a fair trial without counsel. Under our adversary system of justice, how can our civilized nation pretend that there is a fair trial without the counsel for the prosecution doing all he can within the limits of decency, and the counsel for the defense doing his best within the same limits? And
Mr. Chief Justice, may it please the court. Clarence Earl Gideon had a fair trial. The trial transcript shows that he took an active part in his own defense and that he possessed much skill and facility in questioning witnesses. Also, his previous record of 4 felony arrests indicates that he was not wholly unfamiliar with criminal trial procedure. Judge McCrary, who tried the case, says, and I quote, that it is his opinion that Gideon had both the mental capacity and the experience in the courtroom at previous trials to adequately conduct his defense. He did as well as most lawyers could have done in handling his case, unquote. We have been asked to discuss today whether this court's holding in Betts versus Brady should be overruled or modified. We say that it should not, for several reasons. First, there is no historical basis for requiring states to automatically appoint counsel in all cases. Next, the rule in Betts versus Brady provides a clear and consistent standard for determination of the right to counsel. There are special circumstances that should be considered, such as the prisoner's illiteracy or youth.
How do you know what the special circumstances are?
Every time this court decides a case, we know another special circumstance.
Well, in recent years, in 4 cases, I think, we have reversed cases from your state every time you said defendants weren't entitled to counsel because of special circumstances.
We prefer case-by-case adjudication. It may not be precise, but we prefer it because it gives the state some freedom in devising its own rules of criminal procedure. This court has never laid down any fixed rules on the right to counsel.
What about the Scottsboro case? Doesn't that lay down a rule that lawyers are required in capital cases?
That was decided on the circumstances.
Perhaps so, but subsequent cases have made clear that there is a fixed rule for capital cases. There's no point in your arguing that.
What historical support have you found for the distinction between capital and non-capital cases?
Your Honor, I can't think of any.
I can't either. That's why I asked.
Well, there is a practical distinction between capital and non-capital case. You want to draw the line somewhere. Everyone is fearful of being put to death.
Maybe they're fearful of spending years in the penitentiary, too.
I would like to restate one of our basic contentions. When special circumstances warrant, this court can order states to provide lawyers. But by imposing an inflexible rule that every defendant is entitled to a lawyer in every case, we feel that this court would be intruding into an area historically reserved to the state. It would stifle state experimentation
For example, the state might eliminate prosecutors as well as defense counsel and leave the whole trial to a judge.
Don't go too far now.
Look, Gideon's not a lawyer, but you say he's capable of representing himself. Do you also think he should be allowed to represent other defendants?
If a defendant asks for him, I'm sure a judge wouldn't object.
Well, the local bar association might.
I hope that this court will consider the consequences of overruling Betts versus Brady. Grave consequences as I see them. The new doctrine of giving everyone a lawyer every time he asks for it would necessarily extend to the most trivial cases, creating a tremendous burden for the taxpayer.
The next thing you know, indigents would also be demanding other free services, psychiatrists, expert witnesses, and so forth. In effect, this court would be requiring the state to adopt socialism or a welfare program. Also, please consider this. Of the 7,800 convicts now in Florida prisons, more than 5,000 were tried without counsel and might be eligible for release if this court overrules Betts versus Brady. If this court does reverse, we implore it to find some way to make it not retroactive. We have followed Betts in good faith.
Are any of those 5,000 prisoners in Florida illiterate?
Your Honor, I have no way of knowing.
But what do you think?
Yes, I don't know, but I suppose some of them are illiterate.
This court has ruled that an illiterate defendant is entitled to counsel, even under Betts and Brady. Illiteracy is a special circumstance. Any illiterate among those 5,000 has been deprived of his constitutional rights. Mr. Fortas, do you wish to say anything in rebuttal?
You see, this is socialism. Socialism at its finest.
Okay.
But you can see the concerns of the justices. Now,
Absolutely.
I always say that the fix was in on this case from the beginning, in the sense that I think the justices were really, they felt bad about the Betts decision. I think in the intervening 20 years, the fact that all the states, or most of the states, had come up with procedures for the appointment of counsel embarrassed them. I think that they thought that Betts was wrong when it was decided and should never have been decided, but the country wasn't really ready for that in 1942. But you know the fix was in because Mr. Gideon filed his petition in former pauperous, and the Supreme Court appointed an attorney to represent him, and they appointed the #1 attorney in all of Washington, D.C., which at the time was Abe Fortas, a later associate justice on the Supreme Court himself. So you can see that the Supreme Court, they could have picked any lawyer, but they picked the one guy who they knew had the intellectual chops, so to speak, and the office staff support system to do a really amazing job. I feel a little bit sorry for the Attorney General for Florida, because he certainly does not come off as an intellectual giant in the case, just based on his southern accent alone, his pronunciation of different words. But you know what he did? He had some very good points, and the main thing he's bringing out is this issue on petty offenses. You know, how far down the food chain do you want to go?
Right.
So
Exactly.
the dividing line, really, then, coming out of Gideon versus Wainwright, is that the Sixth Amendment provides for the appointment of counsel in the United States through the 14th Amendment for people who have been charged with crimes. And just to distinguish the distinction between a crime and a petty offense, from the Supreme Court standpoint, the only real sure indication as to whether an offense is a petty offense or a criminal offense is the authorized level of incarceration. That's the only objective way of telling it. So the Supreme Court just made a cutoff there, saying that if you're charged with an offense which carries a potential jail term of 6 months or less, that is by definition a petty offense, and you have no right to counsel. By the same token, if you're charged with an offense that has a jail term of 6 months or greater, and you're an indigent, then you're entitled under the Due Process Clause of the 14th Amendment to the appointment of counsel by your own state court.
Right.
And that was and still is the law to this day. I mean, nothing has significantly changed in terms of your right to counsel. Just many people will be surprised to hear this, but it's just the honest truth. You do not generally have a right to counsel if you're an indigent charged with a petty offense in the United States. Now, again, I'm talking about under the United States Constitution.
Correct, right.
Other states, either procedurally or under their own constitutions, can provide this, but under the Sixth Amendment, as it applies to the states now through Gideon, through the 14th Amendment, no right to counsel under those circumstances.
And so how has that developed in New Jersey then? Because in New Jersey, we see a little bit of a different standard.
Well, New Jersey had a kind of a confused history as well. For the longest time, we recognized, following Gideon versus Wainwright, that there was a right to counsel for indigent people charged with petty offenses, or excuse me, with criminal offenses. Of course, these were people that were working but weren't being paid. I mean, the criminal practice in those days was certainly much smaller than it is now.
The attorneys you're talking about not being paid.
Well, the attorney's not being paid, right.
Yeah.
And when I say that, you have to look at it in the context that certainly there were serious crimes in those days, and people who were indigent, which is the vast majority of criminal defendants, were entitled to counsel. But there was no public defender's office. There was no formalized mechanism for providing counsel for these individuals. So in the era of State versus Rush, the idea was an attempt to come up with some mechanism for getting at least expenses and other out-of-pocket advances covered by some governmental entity.
Right.
And it's really kind of a constitutional crisis for the Supreme Court of New Jersey, because you have all these private defense attorneys out there representing indigents on an assigned basis, putting time and money out of their own pockets, and it's just not fair that they have to kind of support the criminal justice system when it's really not their individual private obligation.
Right.
So rather than order the legislature to do something which is of dubious constitutional authority, the New Jersey Supreme Court made a determination that the entity that really is responsible for taking care of this is the county. In that era, the county prosecutor was the chief law enforcement officer of the state, or excuse me, of the county, and the county government was really the chief funding agency for the prosecution of criminal cases. That being the way things were, the Supreme Court ordered that any reimbursement that was going to be done to members of the defense bar who were assigned to represent indigents in criminal cases would come from the county. Okay, they would be the proper agency. So that's the way it really kind of continued to be until the legislature created the Public Defender Act, which provided for the professional staffing and payment of attorneys to represent people charged with criminal offenses who were indigents. Okay.
Right. So, and the Rush case is from 1965. That's the era that you're talking about?
I always forget whether it was 62, 65, but it's an older case. It was not long after Gideon versus Wainwright. So I mean, Gideon versus Wainwright was still, that had been in the mix at that point. But it was really more of a practical problem. How are these individuals going to be paid?
Right.
It wasn't a question of if they were entitled to counsel. It was just a question of how the attorney is going to be reimbursed for their time and effort. Okay. So at some point, New Jersey has to grapple with the problem of people who are charged with petty offenses. The one question left open by the United States Supreme Court in the Gideon versus Wainwright case. And I don't know that anybody could really seriously argue that an individual charged with a parking ticket or some type of traffic violation should constitutionally be entitled to the appointment of counsel. And as I indicated a moment ago, the United States Supreme Court has never ruled that that is in fact the case. But this was the precise issue that came before us in the Rodriguez versus Rosenblatt case. And this is why this became such an incredibly important landmark decision, because the holding of the court back in 1971 immediately started impacting on the lives of pretty much any indigent person that walked into municipal court who was facing serious charges. Suddenly, this is an individual who is now entitled to have an attorney represented for him. Okay. So, what's the rule of the case? Number one, the Supreme Court acknowledged that the right to counsel as an indigent person charged with a petty offense is not, and and I repeat, not one of constitutional dimension.
Right.
Okay? Now, at the time that Rodriguez versus Rosenblatt was pending, there was another case before the Supreme Court that the New Jersey Supreme Court was not sure how it was going to come down. That was Argersinger versus Hamlin. So they were really kind of working in the dark a little bit, and basically said, look, we're going to rule that it's not a matter of constitutional dimension unless and until the United States Supreme Court tells us otherwise.
And they said that specifically a number of times in that opinion.
Right. They're not. They were just not sure how the United States Supreme Court would come down on the issue, because the court very easily could have said that it's a matter of constitutional dimension, just as they did in the Gideon versus Wainwright decision.
Right.
But the first rule that comes out of Rodriguez versus Rosenblatt is that when we're talking about petty offenses, there is no constitutional right to counsel, okay? However, just as a matter of fundamental decency and fairness, the court decided that individuals who are charged with petty offenses and are facing what are called consequences of magnitude, and the consequence of magnitude in that era really, and it's not particularly well defined when it comes to license suspension, but let's just kind of go through it. I'll give you the modern day version of it. It would involve a jail term of any length, starting with 1 day. Number two, they utilized the word substantial license suspension in the case and later on say license suspension. So I would imagine you could make the argument that even a license suspension as short as 1 day would constitute a consequence of magnitude. And finally, money. The court was kind of, less than candid in terms of the amount of money, but the guidelines to the court rules have now specified that the money is $750. And by the way, just two things about money. Number one, it doesn't matter whether the money is divided among fines, restitution, drug penalties, whatever it may be. That's irrelevant. It's the sum total of the money, not who's getting the money at the end of the day.
Okay.
All right? So it could be a $500 drug penalty plus $150 restitution plus a $300 fine. As long as the total amount of money adds up to $750 or more, that constitutes a consequence of magnitude. And when the Supreme Court Committee, Municipal Courts, was trying to recommend this to the Supreme Court of New Jersey for being adopted as part of the guidelines, they took into consideration the amount of money you typically pay for conditional discharge in that era if you had a drug offense, which is actually going to be a little bit more than $750 now that they think of it. But that seems to be the working total. I know that there was an effort by the Supreme Court Committee on Municipal Courts in the last rule cycle to get the Supreme Court to increase that amount of money, and that was rejected by the Supreme Court. So they've decided the $750 is the magic number, at least for now.
Interesting.
So, jail term of at least 1 day, license suspension, I guess, of at least 1 day. The law's not as clear on that. And money of over $750, that's going to constitute a consequence of magnitude. And by the way, I want to talk about this jail part for a second, because the Supreme Court in Rodriguez doesn't really specify that 1 day is a consequence of magnitude in the sense we're talking about. But the subsequent case law has made that abundantly clear. The main case dealing with this is an attorney. It's not a disciplinary case in the sense of somebody violating the RPCs necessarily, but it's an appeal from a contempt of court judgment where the attorney was given a jail term. It's called In re Daniels. And in the Daniels case, the Supreme Court really talks about even 1 day of custody constituting a consequence of magnitude. So, if you have a person who is indigent, and that person has the possibility of being sentenced to 1 day of jail, which often is mandatory in the criminal context, or license suspension, which is very, very, very common in municipal court on a mandatory basis, or monetary assessments of $750 or more. Those are consequences of magnitude, and that person is entitled to the appointment of counsel. All right? Now, again, having someone appointed as counsel and the money part of it, those are two different things. When this case was decided back in 1971, I don't know that there were any formal municipal public defenders in the state at all. Certainly, following Rodriguez versus Rosenblatt, many towns found it advantageous to have, by ordinance, a a public defender appointed to handle these types of cases. But there was really nothing statutorily or otherwise that supported having a municipal public defender. So the courts also relied on appointment of counsel, again, to come in and take care of these individuals when counsel was necessary to be appointed, but yet there was no staff public defender because the town didn't adopt a public defender.
Right, exactly.
Of course, after public defenders came online, it became much easier for judges then to have counsel available, and I dare say the number of people getting counsel increased tremendously. And the judges had a lot more latitude in dealing with these cases, because before, the judges had to think, gee, do I really want to go through the trouble of appointing some poor attorney to come here and represent this guy, when, really, if he's going to get some kind of jail, something that's other than a consequence of magnitude, we can avoid all that stuff.
Right, right, exactly.
So that's really what, was through the initial years following Rodriguez versus Rosenblatt, we relied on a series of appointed counsel, with the public defender being a very rare entity in New Jersey. True to form, the United States Supreme Court decided Argersinger versus Hamlin shortly after Rodriguez versus Rosenblatt, and it was really kind of a compromise decision, because the ruling in Argersinger really doesn't provide for counsel in those cases where there's a consequence of magnitude and someone's charged with a petty offense. Rather, it talks about jail terms only, and jail terms in fact. So the way I'd like to describe the rule set forth in Argersinger is this: that in the United States, no one can receive a jail term unless one of two things has happened. Either A, the individual had an attorney representing him, or B, the individual effectively waived his right to have an attorney, okay? So, by having an attorney, he either paid for an attorney or he had a public defender or appointed counsel, and under those circumstances, the judge is perfectly free to impose whatever sentence is authorized by law, including a jail term. Or, alternative number two, the defendant freely, voluntarily, and knowingly gave up his right to counsel, following a painstaking inquiry by the judge, explaining the benefits of having an attorney, as well as the fact that attorneys can sometimes not only be useful in the issues of guilt or innocence, but also in the issue of sentencing.
Right.
Most of the time, that's where you make your money.
Right.
So, if a defendant freely and voluntarily waives his right to counsel, then there's no problem with the judge incarcerating that individual according to law. But in the absence of one of those two things, it's really a due process violation for a judge to order a jail term. Okay.
Right.
So, Argersinger versus Hamlin was intended to make sure that no one would go to jail in the United States, regardless of the charge, even for a traffic offense, even for something as silly as careless driving or speeding. You just can't get a jail term unless you're either represented by an attorney or you effectively waive your right to counsel.
Right, exactly.
I see this violated all the time in New Jersey courtrooms, and it's really kind of embarrassing. And I know you've seen it yourself. You'll come into court, and the judge will go on the little television. He's interviewing the people from jail through remote television.
Yes.
You've seen
yes.
that, right?
Oh, yes.
And why are most of them in there? They're in there because they had fines. They didn't pay their fines. Right. So a warrant got issued for their arrest, and there they are. All right? And what I see happen over and over again is the judge will engage in a colloquy with the defendant and say to them, okay, well, you've been in jail for 10 days, 12 days now. Would you like me to just wipe out your fines and just give you 10 days credit for time served, and you'll do a couple more days and you can go home, all right?
Right.
And the defendants, they just jump all over that because it means the case is going to be over.
Right.
But there's never any effort, from what I see, to appoint counsel. Certainly no effort to get a waiver of counsel. I mean, it never even comes up. And it's distressing to me because it demonstrates a lack of knowledge of the requirements of Argersinger versus Hamlin, notwithstanding the fact that the defendants are happy and feel that this is, beneficial to them, because I guess it is. They're going to be getting out of jail.
Right.
I think the proper way to do it is to have the public defender, pre-interview all these individuals, enter his appearance on the record, and advocate on their behalf,
right.
rather than having the judge engaging in what is really essentially a one-way plea bargaining with these defendants.
Right.
Have you seen this happen?
I have seen it happen. I've also seen it in the alternative where the public defender does come forward and represent the individuals.
Right.
But our practices are in different areas of the state. I'm up in North Jersey, most is Essex County, so most of the public defenders do come involved in those types of colloquies.
Yeah, down here in my county, that's the universal rule that the public defenders, well, it's actually not universal. One court doesn't do it because of money issues. But the public defenders typically will have an opportunity to speak to all the defendants ahead of time. So you immediately lose all the Argersinger versus Hamlin issues.
Right.
The judge doesn't have to worry about getting a waiver because there's not going to be any waiver because everybody gets the public defender.
Right,
And
exactly.
then they either get jail or not, whatever. But it certainly complies with both the letter and spirit of the law. Getting back to Rodriguez versus Rosenblatt for a second, and I can't stress this enough, is that there is no constitutional underpinning to Rodriguez versus Rosenblatt, either under the United States Constitution, as we talked about a few moments ago in the context of Gideon, or under the New Jersey Constitution.
Right.
It's just a position the Supreme Court was not willing to take. But it really didn't matter. I mean, constitutionally, the Supreme Court of New Jersey is responsible for overseeing the administration of criminal justice in our state. I mean, that's just one of their responsibilities in a constitutional sense.
Right.
And they just were of a mind that, as a matter of simple fairness, of procedure, that indigent people charged with a consequence of magnitude are entitled to counsel. But not as a matter of constitutional dimension, really as a matter of procedural.
And based on a fairness, and that a judge has to make sure that the proceedings are fair. And one of the cases that we talked about, I believe it was Rush, talks about how the county has all this money to put forward to prosecute an individual. So as a result, there needs to be something on the other side to balance that out to be fair, so that there's a fair process that the defendant's involved in.
Correct. And I think to do so otherwise would, in a sense, shock the conscience of the court, so to speak. You could have many, many situations where people who are indigent would be convicted, jailed, or subject to other consequences of magnitude, and if they'd had somebody to put forward a good defense for them, the outcome of the case likely would have been different. Again, the Supreme Court not willing to say that the New Jersey Constitution applies or has within it this guarantee for people who are charged with petty offenses in our state. But it doesn't really matter. They're able to order it as a matter of their constitutional authority to control the administration of criminal justice. So that's the basis on which they're able to have individuals charged with consequences of magnitude assigned counsel, not as a matter of either state or federal constitution, but rather as a matter of policy that they've adopted.
Exactly.
So this has been the rule of law in our state since 1971, I guess, and it's been decades since that time. You just got to really stop to think. It's really inconceivable to me of how many thousands and thousands of people have had the benefit of counsel as a result of Rodriguez versus Rosenblatt, either in the form of appointed counsel or through the public defender since that time period.
Yes, it's amazing when you think about, well, I used to work for the city of Newark, 500,000 cases on average a year.
Oh, I thought it was a day.
It does seem that way sometimes. And that's a huge number. That's a huge amount of people. And where you're talking about a more urban jurisdiction where you might have come across more people that might fall within the parameters of the public defender being appointed counsel, I mean, that's a lot. That's a big deal for people.
Well, and Newark's not even the biggest court in the state. You have Jersey City, and then there's some other busy courts, Campton and Plainfield, City of Trenton.
Exactly.
Bridgewater. I mean, there's a lot of big courts around. So
Absolutely.
You're talking many, many thousands of people who have benefited from this and had much better results, much better outcomes in their cases because of the availability of counsel made possible through Rodriguez versus Rosenblatt.
And Bob, if we can, because we were talking about this before. Now, Rodriguez versus Rosenblatt talks about a consequence of magnitude, whereby it's the possibility of a jail sentence
Correct.
that brings the court to appoint counsel. Whereas in Argersinger, it's the fact that you are getting jail, and that sentence alone, the actual sentence itself, not the potential sentence, determines whether or not someone gets appointed counsel. And I found that to be an interesting condition.
Well, it puts judges kind of in an unusual situation in the sense that they really don't know ahead of time whether or not this is going to be a jail case or not. And then again, it puts judges in the uncomfortable situation where they've got to decide, well, let me see, how do I figure out whether or not this is the real possibility of a jail case? You look at the defendant's prior criminal case history. Again, this is before you've heard one thing of evidence. You look at his criminal case history. In New Jersey, if he has a presumption of non-incarceration, that's certainly something that's going to militate in favor of not getting any jail term. You see what the range of fines are going to be, all right? You see whether or not there's a mandatory or discretionary license loss. I mean, these are things that may be going through the judge's mind. See, with the luxury of the public defender now, I think judges are in a much better position to make snap judgments on the appointment of counsel, because there's really no downside to it.
Right.
But it was still a difficult decision for judges to do in the absence of public defenders being present in all the courts. And it took a long time for that to happen following Rodriguez versus Rosenblatt.
Right.
Tough to get the legislature to move off the dime when you're talking about provisions for criminal defendants, even those charged with petty offenses.
Exactly.
In fact, the next major development in the case, we came back to essentially the same issue that was in State versus Rush.
Right.
And that deals with kind of the next rung down on the food chain is these appointed counsel who were representing individuals in the municipal court. And again, the 13th Amendment really kind of technically bars slavery. Technically. So how are these individuals supposed to be reimbursed for their expenses, get paid, and things of that nature?
Right.
Rush really dealt with things up at the Superior Court level. What about the municipal court level?
And how would they be appointed? And is it being appointed fairly? And then, if you're getting paid, that's another issue.
Well, here's the problem with the case. I mean, you have, besides municipal court, you have other situations that will come up where people are entitled constitutionally or procedurally to counsel, and in many instances, the legislature has not provided for public defender services. These are people that kind of fall in the cracks. Many times it's because of things that happened after the adoption of the public defender statute, and the legislature has never gone back and provided additional funding. Just as a couple of examples, let's say in a domestic violence case, all right? You have a domestic violence case where there has been a restraining order, temporary restraining order, or permanent restraining order, doesn't matter. And the defendant violates the terms and conditions of the restraining order.
Right.
But the violation is of a disorderly persons level.
Okay, right.
Now, under the rules of court, notwithstanding the fact that this is a disorderly persons offense, this is a hybrid offense in the sense that municipal courts don't have any jurisdiction to hear these matters. The family court hears the case involving the violation of the restraining order.
Right.
Okay, it's a disorderly persons offense, a contempt of court disorderly persons offense, but the family court hears it. So you don't really have any public defender that's appointed to, locally to hear these cases. And the state public defender is not funded to represent people on disorderly persons matters.
Right.
So these are people that kind of fall in the cracks, so to speak. And typically, unless there's some other arrangement made on a county level, these individuals will have counsel appointed to represent them from some type of a list. There's something just come off the top of my mind, although there may have been action taken by the legislature that I'm unaware of. I know that for termination of parental rights, this is not criminal at all, but yet the consequences are so harsh to the parent that the court has provided for the appointment of counsel in those situations where that occurs. And I'm not sure whether that's done from a list or done through done by the public defender's office. Another one deals with trial appeals out of municipal court. Someone who's found guilty of a petty offense in municipal court wants to appeal that sentence. You have every right to appeal. If you were an indigent in the municipal court, that's perfectly fine, but your appointment in municipal court does not carry over normally to the prosecution of the appeal. So, again, this is a situation where the people are still facing a consequence of magnitude, but the case is going to be heard in the Superior Court. So as a result, there's no public defender.
Right.
The state public defender isn't funded or responsible for representing those types of defendants. So once again, there'll be some type of appointment of private counsel to do that. And there's, I'm sure, half a dozen other examples where public defender has to be appointed. These individuals came from what's called the Madden list, and the Madden list gets its name from the case we were just talking about, the Madden versus Delran Township. And this was just a situation with a very brave attorney who stood up and said, listen, I want to be paid for the work that I did on this case. Somebody's got to pay me. So the Madden list develops in the Supreme Court, basically requires members of the bar to undertake these representations, but to make sure that it's fair, that the assignment of counsel is done on a kind of a random basis where everybody really is kind of in the mix. And theoretically, pretty much any attorney is responsible for accepting Madden appointments, so to speak, and doing the best you can for these individuals. Now, of course, that causes all kinds of problems because you have people who practice patent, copyright, trademark law, the transactional attorneys, or real estate guys, whatever they may be. Right. They may have zero experience in doing, let's say, a drunk driving appeal, or some type of domestic violence case. In order to help these individuals, the Supreme Court got a couple of committees together to write simplified directions on how you put together a defense in these types of cases. So they actually have online instructions on how to put together a defense in a municipal appeal, especially in terms of defending a drunk driving case. They have others for restraining orders. So there's a whole kind of a library of instructions that attorneys who are appointed to represent indigent defendants in these limited circumstances can utilize. But the Madden list is alive and well in New Jersey. Have you ever been called, by the way, on the Madden list?
I have. I represented someone actually in a domestic violence restraining order in family court. But based on my background, I was familiar with what was necessary, and we had a very successfully dismissed the contempt. So yes, I have been called up on that, and I have to say the client was very appreciative of my efforts.
Now, did you spend about a half hour telling the client about Rodriguez versus Rosenblatt, the whole history behind it?
I did not. Unfortunately, I wasn't even really aware of it because being in the younger generation of attorneys, I guess you should say, I didn't really appreciate the fact that, not too far back in time, they didn't have this
Was
ability.
your client worried that this might be socialism?
I don't think so.
No, all right.
I sincerely doubt it.
Well,
go ahead.
No, I was going to say that from my perspective, the interesting thing is that these are individuals who had your benefit, the benefit of your advice and counsel and advocacy. And they were very fortunate to get it. But none of this would have happened had our Supreme Court not said that these individuals are entitled to counsel, just as a matter of policy.
Exactly. I did find it interesting in the Madden opinion how they talk about attorneys that are not versed in these various areas, that they're brought in, they're appointed to represent people. Right. And it seemed almost like the Supreme Court said, well, too bad. As a lawyer, you have to brush up on the law, and you have to know how to represent your client. So, be a man and step up to the plate and do what you got to do. But we know practically, sometimes that isn't always beneficial.
Yeah, you really should compare that to the language they have in State versus Rush, where the Supreme Court says, look, in a criminal case, anybody can do it. The skills of the attorney aren't all that important, and let's just don't worry about it. Just go out there and do the best you can. I mean, really kind of a complete, turnaround from one saying anybody can do it to the Supreme Court saying, well, we recognize that, but do the best you can anyway.
I think also in Rush they said that the development of criminal defense has come so far since, I think they said, since we, meaning the bench, were practitioners,
right.
And it's become a little bit more of a challenge than it used to. It might not have been Rush. Maybe it was in Madden that they talked about that. But.
No, it was definitely in Rush, and this is years before the adoption of the Code of Criminal Justice. So a very frightening decision, and one I think the Supreme Court is not particularly proud of because it's been subject to an enormous amount of criticism over the years by commentators and law review articles, and certainly in a lot of other cases. Sometimes these cases are interesting for the time period in which they're published, but that was an utterly different era in the development of criminal jurisprudence in New Jersey.
But we see that quite often when you look at case law, that it's a sign of the times, and as times change, even the bench has a different opinion as things move forward.
But one thing that has not changed is the holding in Rodriguez versus Rosenblatt. I mean, it's still so much in play these days. And I think what has happened is the law has really, statutorily and case law has really developed around it, because the next significant development following Madden, I think the outcry in Madden and the complaints from the bar were so loud that I think at that point the legislature felt that they really had to take some action. But again, just as the Supreme Court was confronted in the Gideon versus Wainwright with a large number of jurisdictions that had already adopted public defenders in their own states. The legislature was confronted with a situation where many municipal courts had public defenders that had been appointed by their local jurisdictions without any overall legislative jurisdiction to do it. They just did it. They created an ordinance and hired a guy, and there had been some legislation earlier on about, before the formal adoption of the public defender statute, of fees that could be charged to reimburse the municipality for the public defender services, but that was really the extent of it. But ultimately, the legislature got the word following Madden and enacted a formal public defender statute, which then required public defenders in every single municipality in the state, and set forth the parameters upon which they could be appointed. So that brought us full circle to now a formalized procedure where no person walking into municipal court who is an indigent and desirous of counsel would be denied counsel. And I think that that's what the court really wanted at the end of the day in Rodriguez versus Rosenblatt, except that it took decades to get to the point where you had a formalized structure working,
It seemed like the courts wanted to push the legislature in that direction, because in a number of cases they talk about how it's not our position to set these types of statutes. This is something the legislature, this is something the executive branch should address, this is something other than us as the judiciary should address. And you see that kind of language repeated in some of the earlier cases, trying to push the legislature to actually do what they finally did.
Well, there's politics involved in this. I mean, first of all, they have no authority to have, well, I really want to mince my words here, okay, because that's what I'm going to say is really doesn't bear out with what history has taught us. But just as a practical matter, they don't have any constitutional authority to order another branch of government to do anything, especially spend money.
Exactly.
This is political in the sense that the politicians who vote for it can be accused at election time of having been soft on crime, friendly to criminals. And you can see a television commercial, they voted for millions of dollars so that criminals can have the best lawyers, that kind of stuff.
Right.
I mean, these things can be turned around politically. And politicians are sensitive to this.
Sure.
The second job of every politician is to get reelected. You know what the first job is, right? To get elected. So, all these things really had come around full circle by the time that the legislature enacted the municipal public defender statute. And now we don't have that as a problem particularly anymore. And I think that the funding of the Office of the Municipal Public Defender really occurs so that the municipalities aren't going to lose any money, because in theory all the money being paid in application fees should go to defray the costs of the public defender services plus experts and other collateral services that are needed. But it's certainly a much better, more professional way of approaching the implementation of Rodriguez versus Rosenblatt on a realistic basis. But how many decades did it take to do that?
Yeah, a very long time. It seems it would lend a lot of consistency to the way the Rodriguez v. Rosenblatt opinion is applied.
I would agree. And one additional thing that we have to help us to is a recognition of the procedure in the court rules and in the guidelines to the court rules, so that the court rules these days now provide the procedure that judges are supposed to go through to make sure that counsel will be appointed every time there's an indigent who is otherwise desirous of having counsel. That's number one. And number two, the consequences of magnitude in terms of money and how much money an individual earns before that person is considered to be indigent, this is all set forth on objective guidelines, so that a judge can really look at the income set forth in a tax return or whatever other proof the individual has, and making determinations to whether or not someone really is an indigent. So the tables take into consideration income, number of people you're supporting, extraordinary expenses, things of that nature. Because sometimes, just as a matter of fairness, it shouldn't be left to each judge's personal predilections to whether or not an individual meets the definition of indigency. It really has to be done uniformly throughout the state, just on an equal protection basis, if nothing else.
Absolutely.
So the guidelines to the court rules, as well as the rules themselves, provide a lot of guidance for judges in making these determinations. But you know what? I found that in my own experience, that judges really are very hesitant to deny someone the public defender. And I think if they're going to err, they'd rather err on the side of caution. Sometimes that's really kind of a, I mean, I've seen situations where it's very offensive to me. You know, the person comes in and says, you know, I have no money, and fills out a 5A form. It indicates that the person has no money. But as it turns out, the individual is like a student going to Princeton University or something like that. I say to myself, you know, this is a person of privilege. You know, I mean, it just strikes me as wrong as having an attorney appointed to someone who's getting an Ivy League education. But I'm not in a position to make those calls. That's up to the judge. You know, I was thinking also that the Rodriguez versus Rosenblatt has an additional component of it, which is really important in the criminal law, and that's dealing with post-conviction relief applications under State versus Lork and State versus Rissick. Lork really is a product directly of Rodriguez versus Rosenblatt, in the sense that, I mean, initially when the court decided the Lork case, it appeared that based on a case called Baldessar versus Illinois, a plurality decision from the United States Supreme Court, that it was necessary to exclude convictions for sentence enhancement purposes where the defendant was unrepresented by counsel.
Right.
All right. And that was fine, but very shortly after the New Jersey Supreme Court decided the Lork decision, the United States Supreme Court reversed its holding in Baldessar versus Illinois in a case called the United States versus Nichols, and it was a kind of I think it was a 6-3 decision. So I mean, it's a dead issue at this point. So by the next time, this whole idea of whether or not you could get post-conviction relief in a Lork sense, meaning that you were unrepresented by counsel on a prior conviction, didn't waive your right to counsel, and you were either indigent or not. And if you were not indigent, having had an attorney would have made a difference. All the constitutional underpinning for that went by the boards when the United States Supreme Court decided the Nichols case. So the next major challenge to this came before the New Jersey Supreme Court in a case called State versus Rissick. And I remember when this was pending, I was really worried about it because I thought that might be the end of Lork. And, you know, a lot of defendants, Lork is their only hope, you know, in terms of staying out of jail. But I was happy to see that the New Jersey Supreme Court decided, once again, notwithstanding the Nichols decision, that they would continue providing relief to people for these so-called Lork violations as a matter of policy, the same way they had ruled in Rodriguez versus Rosenblatt. But the interesting thing to me is that they likened the policy in Rissick as being required as a result of Rodriguez versus Rosenblatt. Okay, I mean that's what makes it necessary to do these things. Look, Rodriguez versus Rosenblatt says if you're an indigent person, okay, you either get an attorney or you waive your right to attorney. You're entitled to it as a matter of policy. So when that is violated, the underlying conviction really should not be able to be utilized for enhancing a subsequent conviction, at least the jail part of it.
Right, exactly.
And that's really kind of the essential holding of Rissick. So the constitutional part of it is done, but it seemed to me that it was such a strong opinion by the court that the procedure in Lork and Rissick are going to be with us indefinitely. Again, giving continuing vitality to the court's holding in Rodriguez versus Rosenblatt. That's my view of the case law.
It's a very good point, because actually in Lork, they went back to the fact that they were, in Rodriguez v. Rosenblatt, that it was not based on a constitutional basis to provide counsel. Right. And they repeated that again, and yet when we get to Rissick, now they're saying that there is this constitutional requirement almost.
Well, but it's still, I mean, they didn't, I don't think that they went quite that far. I think that they just said that, look, Rodriguez versus Rosenblatt says what it says, and it would be inconsistent with the holding of Rodriguez versus Rosenblatt to allow a judge to violate our holding of Rodriguez versus Rosenblatt, have a defendant who was otherwise indigent plead out without waiving his right to counsel, and then utilizing that conviction to put him in jail on a subsequent offense.
Right.
If the courts do their job properly, then the guy should either get an attorney or effectively waive his right to counsel. And in the absence of that, You know, it's just not fair.
Right.
So, yeah, I have to tell you a little kind of a story. I have a theory about something.
Okay.
Want to hear my theory?
Absolutely.
There is a decision, because this is really the ultimate extension of Rodriguez versus Rosenblatt. And, you know, if you stop to think about this as a progression, you know, you're taking it one step at a time. We've talked about the appointment of counsel for indigents in the context of the death penalty, Powell versus Alabama.
Right.
We've talked about it in the context of people charged with just regular criminal offenses, Betts case, then Gideon versus Wainwright. We've talked about it in the context of people charged with petty offenses,
Right.
Rodriguez versus Rosenblatt, Argersinger versus Hamlin. Okay, but in each one of these there was a criminal component
Right.
to the jail.
Right.
How about jail when we're talking about the civil component of it? Okay, in particular, you're dealing with child support issues.
Right.
This was a matter that came before the court initially in a case called Pasqua versus Council. Interestingly, the counsel in this case is a judge of the Superior Court in Mercer County. But more importantly, the judge who heard this case, the Superior Court judge, she was the assignment judge who heard this case. And certainly, if nothing else, she's a fearless judge and would call them as she sees them. Now, her background was, among other things, she was the presiding judge of the vicinage before she went to the Superior Court and was an extremely active municipal court judge. I think she actually sat in 3 very busy courts simultaneously and heard many, many, many thousands of cases. And I had the honor of being her public defender in 3 of her courts. And she appointed me on a very liberal basis to everybody in sight. And I just don't think she, as assignment judge, could accept the fact that someone who would be entitled to counsel who was charged with a petty offense, but yet someone who was not charged with any offense at all, but yet still could go to jail for child support, would not be entitled to counsel.
Right.
And let's face it, I mean, people who are behind on their child support, many times the reason they're behind is because they're indigent to begin with.
Right.
And often if they had an attorney who could come in and articulate their issues and advocate for them, they may do a whole lot better than they would do without having their own attorney.
Right, exactly.
So I think, knowing her as I do, I think that her municipal court experience played a large role in her feeling that it was high time that counsel be provided for individuals who are indigent and facing jail as a result of falling behind on their child support. Okay, and because I'll tell you, until this happened, you know, individuals I know in certain counties would get locked up for child support, and they would put them in jail and just leave them there. And
Yes.
sometimes they'd be there for weeks and months, clogging up the jail system, not getting anything paid. I mean, they're not out working, and just really kind of a complete waste of everybody's time. And if you think about jail being as a resource, after a couple of days, I think you've got the message. Okay,
Yes.
Staying there for like 3 months is I don't think it brings anything additional to the table.
No, it really doesn't.
So I think this was all kind of going through her mind. I can't speak for her and wouldn't pretend to do something like that. All I can do is give you my theory. She wrote a very long, elaborate, scholarly opinion in the law division, claiming that individuals who are have these child support issues have a right to counsel when they're indigent. Okay, jail is jail, and we have to look at the reality of it as opposed to, don't don't confound form and substance. You're still going to exactly the same jail.
Right.
The appellate division, of course, shot her down and claimed that if this is something that's going to happen, it's got to come from the legislature, exactly what you'd expect from the appellate division, kind of siding with the conservative view and taking the established position. And surprisingly, the New Jersey Supreme Court reversed in the appellate division and siding with her, saying that these are individuals who, as a matter of policy again, have the right to counsel. And I really think that in some sense that there was an idea in the Pasco case that these individuals were also entitled to counsel as a matter of constitutional dimension. This issue was, it went to the United States Supreme Court in an unrelated case, and the holding in the Pasco case was abrogated by the United States Supreme Court last term in a case called Turner. I think it's Turner versus Rogers. So in my mind, it's really kind of up in the air now as to whether or not New Jersey will continue this. I think we probably will, but it'll be just either a matter of state constitutional dimension, or it'll be just done as a matter of policy. But it was kind of an unusual case, and again, the logical extension of Rodriguez versus Rosenblatt, in my estimation.
And so in the terms of Pasqua, so then we would go to the list that we were talking about, the pro bono list, to have these people appointed, because as we talked about before, this is kind of like that person who falls between the cracks. They're not represented by the municipal public defender. They're not represented by the county public defender. So
Madden list.
The Madden list.
Yep. And I'm just, some of the counties have taken the step of appropriating a small amount of money. I know in one county, they hired somebody who's like a public defender who works for the county, and all he does is represent people charged with restraining order violations. They may also have extended him to representing the usually fathers who have fallen behind on their child support.
Mm-hmm.
So, I mean, they do have staff people. They don't work for the public defender's office. They work for the county, and they pay them some small amount of money, but that kind of frees up the balance of all the attorneys in the county. They don't get appointed from the Madden list because there's counsel provided by the county. You have to have a pretty forward-thinking county to do this, but I know of at least one that's done it because I live there. So
where does that leave us, and where are we going after this?
Well, I sit around a municipal court and just kind of waiting my turn.
And pondering Rodriguez v. Rosenblatt?
No, I don't do that. They don't let me use a cell phone in court, so I really have to kind of watch what's going on. And I've never seen in the years that I've been practicing law a greater need for the appointment of counsel. I've never seen more people who are indigent. I've never seen more people who are utterly unable to take care of their financial obligations with the court. Some of the fines and penalties are so incredibly regressive. There's really no regard to the income that these individuals have or their ability to ever pay. To give somebody, just working people or people who are marginally employed or have no employment, $1,000 fine.
Yeah, for the drug charges, the drug offenses.
Or for more serious offenses,
It's crazy.
It's not going to happen.
No.
But many times the judges have their hands are tied. They have to impose that amount of fine. So, given the indigency and the kind of the types of people that are coming before the court now, the volume of cases which is increasing all the time in the municipal court, I just see that the safety valve that has been created initially by the decision by the New Jersey Supreme Court, and then buttressed by the legislation both on the state level as well as the municipal level, creating these positions of municipal public defender. Just its importance is going to increase and increase and increase, and we may see additional staff appointed around the state as the courts become more and more active. But the importance of this enormously important landmark decision, Rodriguez versus Rosenblatt, it's just going to be with us to the indefinite future, and we're going to need it.
I think you're right. I think it's a very important part of our history and our future.
Well, let's get arrested and find out. Tamara, thanks so much for interviewing me.
Thank you, Bob.